Good morning, everyone. Welcome to WorkCover Queensland's common law webinar on bullying and harassment claims and reasonable management action. My name's Tim Loos. I'm a senior lawyer at WorkCover, and I'm your host today. Before we begin, we would like to acknowledge and pay our respects to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work and from which we are speaking today. We thank them and their elders past and present for their ongoing connection to land, waters, culture and community. Joining me in the room today at WorkCover Central are our guest presenters, Damien van Brunschot, Managing Partner at DWF Lawyers, David McGrath, Senior Associate, and Sally Noye, Solicitor at DWF. Also here are Elise and Georgie from WorkCover's comms team, and they're running the show for us today, so thank you both. Anthony Forrester was due to attend, but he's been caught up in an out-of-town settlement conference and sends his apologies. Just some housekeeping. So we record these sessions and we'll send out an email with a link to the recording. It'll also have the slides. I think there's a survey so you can give us some feedback as well. The recording also goes up on our WorkCover YouTube channel so anyone can access it that way. If you are watching on recording because you weren't able to get into the live session, I'm sorry about that. It turns out our technology has a limit to number of viewers we can have live, which we haven't actually hit before. So I think that's a good sign of the interest in this the topic. If you're watching live, you can submit questions. There's a Q&A button up the top. I think it's next to the chat button. So feel free to submit questions throughout the course of things. We'll do our best to get to them at the end. We've also got some questions that we received at registration time. So I think we'll start with those, and if we've got time, we'll move on to the questions that come through. We'll do our best to get to as many as we can. We can't answer any policy or claim specific questions. If you do have any questions along those lines, we encourage you to get in touch with a relationship manager if you've got one, or a customer advisor who's worked on a claim for you in the past. Any technical issues, I believe there's a help button under the More button in the toolbar at the top. So have a look at that. Agenda. Today's agenda, we're going to start by focusing on primary mental injuries and injury trends, as well as touching on what we mean by bullying and harassment. And then we'll move on to unpacking reasonable management action and bullying and harassment claims in statutory compensation. Then finally, we will look at bullying and harassment claims in common law and what employers can do to help prevent and manage these claims. And then we'll move on to the questions at the end. One final thing to add, I'm sure we're all keen to get into it. Anything that we talk about today, either WorkCover or DWF, including in response to questions, is just general information only and shouldn't be construed as legal advice. That's enough from me, I think. I think everyone's probably keen to hear what these guys have to say. Thank you, Damien.
Well, thank you very much. And it's good to see everyone attend because this is a very important topic. It's increasingly important. Compensation is a feature of the federal system. So there's state-based schemes, and across all schemes, there's an increase in psychiatric injury claims. As I'll touch upon, they're more contested, they cost more, and they're increasing. And obviously, as we see an increasing destigmatisation of psychological injuries in the community, which is welcome, there is, of course, a growing awareness. So thank you for joining us for what is a very important topic. All right, let's kick off with the next slide, please. Well, what we're here to talk about is what we call primary mental injuries. Now, what do I mean by that? Well, it's where the claim advance is for a psychological injury. And a secondary psychological injury, in contrast, is a claim that can arise secondary to a physical injury. But here we're talking about an injury that its dominant nature is psychological. And you'll see adjustment disorders and those types of things often commonly arise as well. There's an increase in those types of claims. So there's an increase in people having a physical injury and also having what they call a secondary psychological injury. But let's park the secondary psych because we're here to talk about a primary psychological injury. Now, they arise commonly out of bullying and harassment, and that's the sweet spot today. That's what we're addressing. And you'll see the numbers. That is, in fact, the greatest cause. A traumatic event, they can arise from overwork. They can arise from occupational violence in some industries, health, disability, etc., investigation of complaints, performance management and decision-making processes. So they're the sort of, if you like, factual scenarios that often give rise to a psychological injury. All right, let's look at some numbers. I think this is really interesting because this is a slide that covers off on trends in Queensland. And you can see there that psychological and psychological injury claims, if you look at the dark blue, that's the more recent year, has increased now up to 6,318 from 5,530. So those numbers are on the rise. And as I said, that mirrors other state schemes. And it's quite high compared with, say, strain and sprain. It's about a third. So it's fairly significant. And the next graph is also telling, because what we're trying to convey in that number is the fact that psychological and psychiatric injury claims cost more. Why do they cost more? Because, unfortunately, there's often a breakdown in the employment relationship, or there can be if not managed well. People stay off work for longer, and there's more cost in managing them, particularly because people stay off longer, which people are often surprised about, because we do lots of physical injury claims where there's fairly expensive intervention like surgery and the like. But look at that. You've got psychological and psychiatric injury claims in which people get psychiatric treatment, so not the cost associated with managing physical injury claims, but people are staying off work for longer, they're harder to get back to work, and they're costing WorkCover more, and in fact costing other schemes equally in the same way. So that's an important trend. So the next, and this basically mirrors the Queensland story, but I thought it was really interesting because it's from Safe Work Australia, which is a national data set, more national. And what I wanted to bring to your attention was the number one subcategory of mental stress is work-related harassment and or workplace bullying. So that's right at the top of the type of claims that are advanced. Work pressure, which is very subjective and is problematic at both the statutory and common law arena because it can be captured by reasonable management action, is number two. And exposure to a traumatic event falls about half of the numbers related to work-related harassment and workplace bullying. And of course, I've touched upon occupational violence in health, disability, not-for-profit scene. You'll see a lot of those as well. And so that's an issue that needs to be carefully managed. So that's by way of an overall, if you like, breakdown on the numbers. So I'm going to hand over now to Sally, who's going to talk about what this all means. Oh, sorry, that's for me. My apologies. I jumped the gun, guys. I'm so sorry. So what does this all mean? Well, be alive to signs pointing to potential mental injury if and when they emerge. Okay, now that's really important because there's an increasing destigmatisation. There's an awareness in the community. So it's very much you have to be alive to it. And I think there's a general improvement in that in many workplaces that I encounter. It's still no obligation at law to provide a happy workplace. So I'm quoting from an old case here, that tension may be endemic in the hierarchies associated with workplaces. So you don't have an obligation at law to provide a happy workplace. It may feel like you do at times, but the duty doesn't go that far. And it's always a balancing act. It's not a duty of invasive or dictatorial care. You need to be alive to a person's right to privacy. That's why it's quite problematic if someone comes to you with non-work related stresses. You've got also their privacy and other considerations you need to be alive to. There are limits to what an employer can impose on a worker, having regard to the vital values of autonomy, privacy and dignity. That's the slide I touched upon. For those interested in a case, there's an old case, relatively old in Queensland now, dealing with an ambulance officer at Hegarty, which really takes up that point. And of course, beware if your workplace is inherently risky. By that I mean, there are some workplaces, ambulance, police, other fields of public health and other public facing, where your workplace can be inherently risky. Even, for example, there's a case in the High Court that concerned someone prosecuting sexual offences was considered also to be a risky workplace. So you must have regard to the new code regarding psychosocial hazards. There's been quite a lot of presentation material presented on that about assessing and managing those risks. And a key feature that always comes down in terms of practical measures is respond appropriately to complaints. Don't sweep them under the carpet. There's various ways they can be responded to, which I'll touch upon, and there's various, if you like, how they're escalated and responded, and have policies that concern bullying, harassment, sexual harassment, etc., and comply with those policies. So that's sort of the key issues that emerge. Next slide, please. Okay, what is bullying and what is harassment? Well, there's an interchange between them. One of the questions addressed this actually. Bullying is about targeted behaviour with a power imbalance. So bullying is about, if you like, unwelcomed behaviour or that's targeted, usually endemic in the hierarchy. It's often raised against a supervisor or someone in a managerial role. Harassment can be that, but it's more broadly associated with unwelcome conduct. The term harassment is commonly arises in often, say, the sexual harassment, unwelcome conduct. It can be between two co-workers. It doesn't need to be sexual or other impropriety. It just needs to be unwelcome conduct. And it's often repeated too. Both bullying and harassment, they're bandied around fairly loosely now in workplaces, sadly, but they have specific meanings and that's important to note them at law. Now, the law is always reflective of broader community concerns, and it has to be. So the point I'm making in the second is there's an increasing scrutiny on workplace behaviour with higher standards now imposed. And you'll see that from judicial statements. I quote a case there of Keegan. So there is more scrutiny, I think. There's higher expectations. I mean, what was considered, we all know that, what was considered appropriate even in professional services that is now inappropriate in terms of, if I can call that self-regulating and managing your emotional stresses and the like. So we're all alive to the fact that there are different standards. And that's also a welcome thing in terms of creating a better workplace culture. But as I say, there all is not lost for employers because vicarious liability is a bit more narrowly defined now. You're probably all aware of a case because it's been covered off very often, and it's a case where there's Queensland's unique contribution to the law of vicarious liability. So really, you need to have something that arises in the course of employment. It needs to be much more specific than just the work being the context, and that case is authority for that proposition. All right. Right, I've now hit the mark. I wanted to get off too early, which was a mistake, clearly, but I'm going to hand over to Sally Noye. She's a star in our team and she does a lot of this work on reasonable management action because employers sometimes come to us and say, hey, we've got this site claim, can you help us? And we say, of course we can, we're happy to, because there's a crossover here between, if you like, the statutory and common law process, because reasonable management action actually draws on concepts of old industrial law, etc. And remember how I talked about it being an important exclusionary provision. Okay, without further ado, let's hand over to Sally.
Thank you. So the Workers' Compensation Act is the starting point for any compensation claims, whether they are psychiatric or physical injuries. But today we will be looking closely at Section 32. Section 32 outlines the meaning of an injury as well as reasonable management action. The bolded parts on the slide notes both of the elements of a significant contributing factor as well as arising out of or in the course of employment. These particular aspects are important and a few cases are decided on these points alone. At its simplest, the question to ask is, was the injury caused because of work or was work the mere setting or background of the injury? Asking this question at the outset may lead to an employer to consider challenging an acceptance. But in a bullying and harassment context, this can get somewhat convoluted in that even workers' interactions in the workplace can be considered to be connected to their employment. So this particular aspect of the legislation is often decided in consideration of medical evidence and whether there is any other evidence indicating there were other circumstances such as a personal life event which contributed to the worker's injury. There are many elements we could talk to in depth, but we will not go into them today as the main focus is on reasonable management action. So on that note, if an injured worker sustains a psychological injury in the course of employment and their employment is a significant contributing factor to their condition, the injury will be compensable unless it is excluded under the reasonable management action provisions. So regardless of how a primary psych injury occurred, it's important to determine whether the stressor complained of is management action, and if so, was that management action taken in a reasonable way by the employer. So what is management action? Management action is not defined in the WCRA, but has been examined in various workers' compensation decisions. There's a list on the slide of various examples of management action, but the WCRA actually puts it quite simply in section 32.5, where it notes that examples of actions that may be reasonable management action taken in a reasonable way are actions taken to transfer, demote, discipline, redeploy, retrench, or dismiss a worker. The examples listed there, which you can have a read through, are essentially just various specific circumstances of what section 32.5 says. So case law suggests that to be considered management action, the action must be different to their normal duties or simple day-to-day instructions of the worker's employment. In other words, something more than what is part and parcel of their employment. We note that management action can also involve the inaction by a manager or supervisor. Importantly, however, the way the employer takes these actions must also be reasonable, and if they weren't, these actions will not fall within section 32.5. Slide, please. So then the question is, what is reasonable management action? So what is reasonable is a question of fact, and the test is an objective one. We must consider the circumstances that led to and created the need for the management action to be taken, the circumstances while the management action was being taken, and the consequences that flowed from the management action. For the exemption under section 32.5 to apply, however, the management action must be carried out in a reasonable way. The worker must be able to demonstrate that the decision to take management action lacked any evident and intelligible justification, such that it would be considered by a reasonable person to be unreasonable in all the circumstances. The test is whether the management action was carried out reasonably, not whether it could have been undertaken in a manner that was more reasonable or more acceptable. In general, management actions do not need to be perfect or beyond blemish to be considered reasonable, and whether the management action involved a significant departure from established policies or procedures, and if so, whether the departure was reasonable in the circumstances. So while the RMA provisions limit the types of psychological injury claims, it is often that the RMA provision doesn't apply in bullying cases. This is often, but not always, because bullying is carried out by someone who is not a manager. So even if the employer has good policies in relation to bullying, the injuries might still be caused by that bullying. So then the question is, what if the manager is the perceived bully? We then need to look more closely at the application of the RMA provisions. In saying this, it would be unusual for the QARC or the ICQ to consider any form of bullying reasonable, even if it may be that it was in a management action context. Importantly, however, any unreasonableness must arise from the actual management action in question, rather than the worker's perception of it. So it may be that the worker perceives the manager's or co-worker's actions as bullying, but in actual fact, they were not. We have some relevant cases listed on the slide here to help put all of this together, but we'll only discuss a couple of these today. Reasonable management action is the subject of many QARC and ICQ decisions, and it's helpful to skim through some of these in order to properly understand how to determine whether an action is reasonable. So in the King and Workers' Compensation regulated decisions, the worker lodged a WorkCover Queensland claim for psychiatric injury arising out of a series of stressors during her employment with Coles. So the Commission was required to consider 4 allegations here of bullying and harassment caused by her supervisor. These 4 allegations related to a number of issues such as belittling and berating the worker and generally just bullying and harassment. One of these allegations, however, we would like to specifically mention as it provides a good comparison between something that is management action but not reasonable. And that's in the context of bullying and harassment allegation. So the worker in this case alleged her supervisor arranged a meeting at short notice with 2 other store managers. And she stated that she would have liked a witness to be present, but there was no one available at the time, and then the meeting proceeded anyway. So the Commission noted that this situation would put unreasonable pressure on the worker, and accordingly it was found that although the meeting was reasonable management action, although the meeting was management action, it was not conducted in a reasonable way, and therefore Section 32(5) could not be satisfied. Then we've got the case of Gibson and the Workers' Compensation Regulator. So in this case, the worker appealed against the regulator's decision, confirming the claim for compensation was not one for acceptance. The worker alleged a number of causative stressors, including bullying and harassment from other employees and management's failure to investigate and action her complaint with respect to this conduct. Ultimately, the worker's appeal was dismissed on the basis that the worker's version of events was not favoured over the employer's. However, two stressors were considered management action, specifically the supervisor's response to the worker's complaints. So of relevance was a meeting that occurred between the worker, supervisor, and another employee who was actually the subject of the worker's complaints. The worker became agitated in the meeting and the other employee left. So the Commission found here that the dealing of the worker's complaint combined with the convening of the meeting was within the complaint policy guidelines of the employer, and that any stressor on the part of the worker was as a result of her own perception of the meeting and her own unrealistic expectations as to how the meeting should have unfolded rather than the actual events. So hopefully this has been a somewhat helpful discussion around Section 32 of the WCRA. And I'll pass over to David now to discuss bullying harassment in common law claims.
Thank you, Sally. And good morning, listeners. I'm tasked today with providing a bit of an overview of the general principles and case examples of bullying harassment claims in a negligence or common law context. So that is, of course, where an injured worker is alleging negligence or fault on the part of their employer rather than the no-fault compensation scheme, which Sally has just addressed. So the first slide deals with the duty of care owed by employers for psychiatric injury and bullying matters. In some ways, it is uncontroversial. It is the same duty of care that is owed to workers with respect to physical injuries. So the relationship of an employer-employee gives rise to an obligation on an employer to take reasonable care to protect the employees against risk of injury, psychiatric injury, which is foreseeable. And we have a quote there from the seminal case of Tame, which confirms that principle. Reasonableness, of course, is contextual and case dependent. What is foreseeable and what is reasonable in one case will depend on each different worker, each different workplace, and what goes on in those workplaces. I think that's particularly pertinent in bullying claims because as a concept, I think all reasonable-minded people will accept that people should not be subject to harassment in the workplace. And as the case on the screen Wern highlights, it's one thing if one develops a psychiatric injury because of the ordinary work they're contracted to do, and that occurs from time to time, as Damien has just touched on, in cases like first responders and emergency workers or people with high-stress jobs. At the heart of it, people have agreed to take on those jobs, and the foreseeability of the injury and the precautions that need to be taken are flavoured by that consideration. But on the contrary, people do not sign up to be bullied or harassed in the workplace. So a court may be more likely to find an injury to be foreseeable in the circumstances and import a high standard of precautions that ought to be taken. But again, simply because risk of injury is foreseeable does not mean an employer will necessarily be at fault. The focus becomes the response to that risk and the precautions that were taken. And the following slides are really just an legislative encapsulation of the test for negligence and damages claims. I'll just touch on these briefly. The exercise at the assessment of risk is, of course, prospective and not done with the benefit of hindsight, but it is really a contextual analysis. So it'll depend on the circumstances of the case. So in the context of a bullying and harassment claim, if we have a known bully in the workplace and there have been complaints about this person, of course, the foreseeability, the significance of risk and the probability of injury would be higher than in other cases. And that affects the response that an employer must take to discharge its duty of care. I'll just skip through another one, please. I'll just deal with causation briefly because it does become relevant in bullying and harassment claims. So say hypothetically, a large-scale employer does not have an appropriate mechanism for dealing with bullying complaints. The employer could well be in breach of their duty of care, but it may be questionable whether that particular breach has caused an injury. For example, that hypothetical worker may have already been injured due to the bullying prior to a complaint being made, such that the failure to respond to a complaint is not the cause of the injury. So that's where causation in the damages context can become quite important. Of course, in defending a claim, it is better to have no breach at all than trying to rely on a causation argument to properly defend a claim. I'll just move on now to some case law summaries, and these are necessarily brief and truncated summaries of what are quite often lengthy decisions. So I encourage you to have a read of the decisions in greater detail if they're of interest to you. And I appreciate too that these decisions have been spoken about at many seminars over the years by people more knowledgeable and skilled than I. So forgive me if you've heard some of this before. The first case of Ward, a New South Wales decision, I present somewhat of an extreme example of harassing conduct, but also to show the distinction between negligence or primary liability on one hand versus vicarious liability, which Damien touched on earlier, especially by senior managers. I mean, in short, vicarious liability is where an employer is held liable for the wrongful act of its employees if that wrongful act was done in the course of employment, even if the act itself may not have been permitted and went against an employer's own policies and training and the like. So in this case, Mr Ward, the plaintiff, was an accounts manager for the insurer Allianz. His manager, Mr Smith, was said to be an aggressive operator. For example, he brought all the accounting executives into a boardroom when he commenced and said they were to blame for some of the operational issues in the business, and he had been brought to kick them in the head. And further instances, as I mentioned on the slide there, of extensive physical and verbal abuse over a period of about 14 months, including slapping Mr Ward across the back of the head and shoulder charging him as he passed him in the hallway. Interestingly, another co-worker complained about Mr Smith and he was moved to another role. However, about 7 years later, the plaintiff Ward had a breakdown, developing PTSD and depression, with the evidence being that was caused by Smith's conduct, that is the manager. Allianz were held liable for the conduct. The court was satisfied that it was an expected consequence of the conduct that some form of psychiatric condition would arise, and Mr Smith was recklessly indifferent to the consequence. Further, the abuse by Mr Smith was done in the apparent execution of authority vested in him as manager in terms of marshalling his staff. So ultimately, Allianz were liable. They weren't liable in negligence because they had a proper system for responding to the bullying complaints, implemented it and removed Mr Smith from the role. Nevertheless, liability was established on the vicarious grounds and damages were awarded in the order of about $1.4 million. So that decision highlights, just as others do, that managers, when they behave badly, and when they behave in the course of their employment, that liability can still be sheeted home to an employer, notwithstanding that there wasn't a failure of policy or systems. The next case of Keegan and the Suzanne Corporation. I'm sure many loyal shoppers to the Suzanne Corporation out there. Ms Keegan was an assistant manager at the retail chain, and she alleged psychiatric injury over just a course of 11 days of bullying and harassment conduct by a new manager, so quite a short period of time. Ms Keegan, the plaintiff, came back from maternity leave and was subject to the manager's behaviour, including being left out of management matters, spoken to aggressively in one instance where a mop was held about 10 centimetres from her face, and there were other criticisms of Ms Keegan's work as well. Ms Keegan raised concerns about this behaviour with another superior, and she was in tears when doing so. So notwithstanding the relatively short course of conduct, the court found an injury was foreseeable in the circumstances. Here, the real failure of the business was not following its own bullying and harassment policy, which required complaints to be taken seriously and not trivialised. Justice Henry, the Supreme Court judge who heard the matter, was quite scathing of some of the responses. The plaintiff was told to, quote, put some lippy on and go home to your bub, and further that the employer's preferred approach of Keegan and Clark sorting out the problem amongst themselves was not acceptable in the circumstances. So this case was a case of a primary breach, that is Suzanne's own failures, rather than the vicarious liability of its manager Clark, and damages were awarded to the plaintiff in the order of about $240,000 in this case. The next case is one of Robinson, which I alluded to earlier. Miss Robinson was a director of nursing at Cape York Health, and she was subject to managerial mistreatment by her CEO over about 10 months and sustained psychiatric injury. Effectively, the conduct included blaming, humiliation, belittling and the like. As a matter of principle, Justice Henry observed that the seniority of the alleged perpetrator matters. As I said, as I put on the slide there, the fact that someone with such a powerful influence over an employee's fate is the person who's targeting that employee obviously tends to have a crushing impact on the employee as to heighten the inherent risk of psychiatric injury. Sadly, this case involves such conduct by a CEO, so it's not hard to see why vicarious liability was established in the circumstances and an award of in excess of $1.4 million was made. The next case, one where the employer successfully defended the matter and one which speaks to the importance of showing actual bullying rather than the perception of it, is Robertson in the state of Queensland. This was an enrolled nurse who brought a claim saying that she had been badgered, bullied and mobbed by some of her colleagues. The issue arose out of some performance management steps that were taking place. Ultimately, the trial judge rejected that many of the allegations of bullying occurred at all. But as to the foreseeability of the injury, the court found that it's important to distinguish between industrial complaints and a person's issues within the workplace and complaints about failing to cope with psychiatric stressors. So it was material that Ms Robertson in this case did not complain that she was being bullied, badgered or otherwise treated unfairly. And the lesson to emerge is that an employer is entitled to take reasonable management action to manage their staff. Indeed, the Court of Appeal noted that it's especially important that they do so, that they deal with perceived incompetence of their employees in a health setting where the competency of their staff is an issue that poses a risk to other people. And this is, of course, never necessarily pretty, managing staff and doing it in a delicate way, but this decision can provide some comfort for employers. The final case I want to speak about briefly is Robinson and Lorna Jane, just to highlight a point about social media uses. Much more to it in this case. There were many allegations, but I just want to highlight this one in brief. There was an allegation with respect to bullying harassment via a manager's personal social media posts. And we all be, of course, familiar with cyberbullying. The part of the allegation concerned the manager making posts in contravention of the employer's social media policy. Now, in this case, it was speculative whether the posts were about the plaintiff at all. But you can see, as I said on the slide there, the court found that they were not, that is, the employer was not vicariously liable only because the employer had a policy against the wrongful act, the offending employee knew of the policy, and that the employee, that is the manager, disregarded the policy and did the wrongful act anyway. The court placed great weight on the fact that the posts were the workers' personal posts on their own Facebook page, and there was no evidence that the employer, Lorna Jane, had any knowledge of it or permitted the worker to post in that way. So again, it's a decision of some comfort to the employer, but this is what, almost 7 years ago now. It's not difficult to see in the modern age and in the post-COVID era to discern of situations where bullying by social media or electronic communication could visit liability on an employer where working remotely and working electronically, communicating in that way is not only ubiquitous, but it's often necessary in the workplace for things to be done efficiently. So, in short, policies need to be there, they need to be appropriate, and I doubt very much that the court would look on cyber interactions in any way differently to in-person interactions with respect to foreseeability and questions of that nature. That's the last case for me. I'll pass back over to Damien for some practical steps that he's identified for responding to bullying, perhaps drawing on his many, many years as a managing partner of our firm.
Thanks, Dave.
A happy firm.
A very happy firm. Thank you, David. I appreciate that. And some, just to go back, one of the takeaways I took from Sally was the notion at a statutory level that reasonable management action is both substance and process driven. In other words, was the conduct management action, was it in substance reasonable, and was the process also reasonable? So just be alive to that. And in terms of David's point, he talked about negligence and also vicarious liability. And I brushed over it a bit on Shockman, but Shockman is authority for, that's a co-worker who urinated in a work camp accommodation on another co-worker, And there was an attempt to argue that that was captured by vicarious liability, but of course the court said no, employment was just the context. It's still got to arise in the course of employment. But obviously the cases David cited are really important, because if you've got a manager, they are in fact tasked to manage. That means to interact, to set performance expectations, all the usual plethora of duties that a manager undertakes. And if they're doing that in a way that involves impropriety, bullying and harassment, well, then it's easy to see how a court can seize upon that and say, well, that is quite different because that arises in the course of employment. Okay, so thanks for that, both Sally and David. Now, all is not lost, because you can do things and you ought to do things, and we've come a long way in workplaces. We've come a long way in terms of psychological injury claims and their management, and we have much more awareness about it. It's an evolving, obviously, project, but I think the first thing you need to do is establish clear policies and procedures, and that may be comprehensive anti-bullying, anti-harassment policies. You need to clearly define what's unacceptable, provide examples, and importantly, outline the procedures for reporting and addressing incidents. You've got to have a reporting culture, guys. It's really important. When things are swept under the carpet in these types of environments or workplaces, they fester and cause problems. So that's probably the first thing. Make sure your policies are followed. You spend all this money, get a good HR person, getting in place great processes and policies, and years later, when lawyers are looking at it and looking at the factual scenario, they're all over it if they find that for whatever reason you didn't follow your own process and policy. So the secret is articulating it well, defining it well, and following it well. So that's the trick there. Okay, awareness, training and education, that's really important. A lot of workplaces are doing that now better, and that's a really good thing. Training and education, it needs to be ongoing. It's not just a tick and flick. It needs to be revisited regularly about what's acceptable and what's not, so people clearly understand that. And so that's probably linked to the first point as well. Lead by example, I think that's really important. And I think that's often overlooked. I think all of us in workplaces that are leaders have to lead by example in the way we treat others. And, you know, as I say, you do as a leader set the tone of the organisation. And by leaders, I'm defining it broadly to people at a managerial level, not necessarily at the C-suite level. So people that lead others, be alive to that, be alive to the impact you have, be alive to the fact that you need to lead by example. It's important to promote an inclusive culture. I think that's important more broadly, where people feel they can turn up and be authentic and themselves, to use the new HR language. That's really important because it also promotes reporting and openness and transparency. So there are obviously some cultural considerations always at play in any bullying and harassment claim. Support systems and employee assistance programs, they're fairly stock standard now, and they're welcomed, and I think they're good because you're able to address issues when they emerge. And it may be a work-related stress or psychological issue. It may be a non-work-related stress or psychological issue. But, you know, you have to be alive to this and give people the support and assistance that they need. But remember as well the importance of privacy and confidentiality in that context as well. So those are the sort of considerations you have to navigate there. The next thing that I'm talking about there is regular communication and a reporting culture. And a reporting culture I've touched upon, that's very important. You need to have an environment where people can come forward, and lots of times they don't, and that's where problems really emerge. And you need to keep records. You need to ensure that that's recorded and it's looked at properly. And that dovetails nicely into the next point. Investigate and address all complaints. Now, I'm not saying it's a nuanced approach. I'm not saying that you need to bring in external investigators, appoint something with costing you a lot of money. You may need to do that if it's a C-suite level or if it's a highly sensitive matter involving, say, sexual harassment. But you may not do that. It's a very nuanced approach. But the common theme is you have to ensure that they're investigated and addressed, and it may be even internally, it may be done externally. You need to demonstrate to courts that you've looked at this seriously. You haven't turned a blind eye, you haven't put your head in the sand, and that you've and that you've made findings of what transpired and you put in place consequences for if there's been violation. And that goes back to the first point about did you follow your process and policy. So I really encourage that, guys. Investigate all complaints. Take them seriously. You might have a view that something perhaps is less serious than others, but just be alive to the fact that people respond very differently in psychological context. What you might consider to be a moment that isn't of any great moment in the way you manage stress, people can be deeply affected by it. So just be alive to the vagary of the human condition here and the fact that people respond very differently at different levels of the workplace. So please, I encourage you to investigate and address all complaints. Here's a plug for our HR friends. Make sure they're resourced and trained HR professionals to give advice and address concerns. And as well as having them in many sophisticated workplaces on board in your organisation, you can outsource that and get advice too where needed. And as I said, have consequences for violation. So it's really important if you make a finding that's been impropriety, you do something about it. You counsel, depending on obviously the breach that you found. The violation and the consequences is all very dependent upon what you found. But you've got to have consequences. It may just be at a lower level counselling, training, etc. It may be at a higher level, obviously termination, more rigorous performance and other management measures. It may be removing someone from an interaction that is unhelpful or a manager that is unhelpful. There's obviously a whole plethora of things that you need to explore that is nuanced and is responsive to the situation that you find yourself in. But the point is you need to have some consequences for violation, and that's the point I made there. All right, now, I hope you find that useful. Do we have some... I think we do actually have some questions that are, if you like, pre-made.
Yeah, this next slide is the questions that came through. People can submit questions when they register to attend. So these are the ones that came through in advance. So we'll run through these ones first, and I believe some more have come through, which I will put you on the spot.
Lovely.
Shortly. I think that first one was the one that was covered in the content, wasn't it? Difference between bullying and harassment, I think it was back on slide 12.
It was.
If you wanted to expand on that, feel free, but otherwise we'll move on.
No, just to say this, bullying is often a power dynamic, harassment is unwelcome conduct. They're the key points of difference.
Question number 2 up there. How do you proceed if you don't see the bullying yourself? So you're relying on what the victim is saying and the other party is denying any wrongdoing.
That's a common scenario. You want to address it?
Yeah, well, I think it's, as you mentioned, Damien, investigation is key. It's probably rare in a workplace where there's just one isolated incident between two people which no one has observed. The key is, of course, to investigate something, and it may be that it is just one isolated thing, and it's difficult to make substantial findings based on a he said, she said, if we can put it that way. The outcome of that may well be that perhaps now you are on notice. You perhaps can't take steps to discipline or move somebody if there are employment law issues arising and there's no findings being made. But there has been a complaint made, it's been investigated, you followed your processes, and you are potentially now on notice. You've really got to be alive to other things. But as I was alluding to earlier, it's rare that something is going to be so isolated. There will be people who can perhaps speak to, those two people's relationship, whether they observed anything, whether there's any, collateral evidence that suggests one conclusion's more likely than the other. And you base all that and you factor everything in and come to your conclusions. And as you say, Damien, document them and take the action that you need to take. But I appreciate it is often difficult where the bullying and harassment might just be between two people and no one has observed it. It can be very difficult to reach a conclusion in those situations.
Absolutely. Thanks, David.
We see in the stat determination level, sometimes you reach that point where there's just not the confirmation or not enough information, and now our claims determination people just have to make a decision on the information they've got. What was more likely to have occurred?
That's right.
Number 3, should I encourage workers to attempt to resolve issues themselves initially by speaking up to the alleged bully? Can this be effective, or can it incite further bullying?
Well, I think Dave's got a case example, but I think the point to keep in mind here is it's nuanced. It depends on the nature of the allegations of bullying. If it's of a higher level, these things exist on a spectrum. It's not a good idea. I know mediation can be effective workplace tool for interpersonal issues, but when it crosses the line to bullying, it is a little bit problematic. It's not impossible if it's a lower level and perhaps it's you don't find some aspects substantiated, but generally I think once it comes mediation and putting people together in the context of interpersonal issues is helpful, but it can backfire on the issue of bullying. Dave, you've got it.
Yeah, I was just going to touch on, as I mentioned in an earlier slide, that case of Keegan and Suzanne's. Justice Henry was quite scathing that the approach taken in that situation was that the worker was effectively left to deal with the bully by themselves. And one can readily see how that might be an inappropriate course in some cases. As I said, for lower level things, it may be that just facilitating a dialogue is the appropriate course, but as Damien says, it's nuanced, it's fact specific. Important thing is once an employer is aware and a complaint's been made to them, can't just assume that the staff are going to take care of it themselves. It needs to be properly managed, it needs to be investigated, and you can't make two people get along, of course, but you can make sure that people are properly counselled and made aware that bullying and harassment in the workplace is plainly inappropriate.
Thank you. Question 4, what is an employer's duty of care if an employee faces bullying at a client's workplace?
I'll be brief on this, but from an employer perspective, you can't wash your hands of it and say, well, it happened at a client's workplace because you've got what they call it law and non-delegable duty of care. So that means you've still got to investigate it and you've still got to find out as much as you can. Now, you've got no control in terms of the employment control over the client and the perpetrator of the client, but you certainly have to manage your employee by investigating and maybe even taking steps, depending on what you find, to remove them. You need to take steps to notify the client if you find certain conduct is inappropriate. You might have rights under your contract, depending on if there is any written or other contract in place in, say, a labour hire or host. But you certainly can't say, well, that's outside of my domain because that employee went to a client's work site, because you're on notice. And you're on notice about how you manage that employee going forward as well, depending on what you find has been the nature and extent of the bullying. So I think that's an important consideration to keep in mind.
Thank you. And the last one up there, if a risk for a mental injury claim has been identified, what steps should an employer take with consideration to reasonable management action?
It does depend a lot on the facts in terms of this. It talks about when a mental injury claim has been identified. Well, it depends on what stage, if you like, of what it arises out of. But obviously, the usual things we see are making sure you investigate, you have a process you follow, you ensure people are appropriately supported. As I said, reasonable management action is both substance and process driven. So it's hard in a vacuum to answer that, because it really does depend upon at what point in time the mental injury claim has been identified. But I hope you can see the reasonable management action from Sally's slide and from the practical tips of the type of measures that you ought to undertake.
Thank you. Elise has passed me some questions that have come through over the course of the presentation today. I've just noticed there's sort of a theme here, and your responses might be veering slightly towards workplace health and safety advice. So just reiterating that this is just broad responses from DWF, just generally on the topic rather than advice. First one there is, what if an employer's HR team is aware of a supervisor potentially engaging in bullying behaviours, but no formal complaint has been received to take action? Does the employer still have an obligation to take action, and could they be liable for breaching a duty of care if they don't?
Well, I have a view on that, and I'm sure David does as well. When an employer knows or ought to have known, it doesn't just depend on what you're told necessarily. It's what you may know or suspect from, say, HR, who's very much armed with the obligation to, provide a harmonious, to promote a level of harmony in the workplace. So my view on that is, to what extent it's known by HR is a bit unusual if it hasn't given rise to a complaint. But if it is known by HR or concerned about, you need to look at it and examine it. And, you don't necessarily need to inflame the situation by having a full-on investigation, but you need to satisfy yourself at HR that the supervisor's conduct is okay, effectively, or not, as the case may be, and counsel the supervisor accordingly. In fact, it's a unique opportunity to cut something off at the pass if that scenario is given to you. It's a unique opportunity for you to jump on, to investigate it, and to maybe come up. Now, you don't need to take a formal external investigation, but you might find there's some substance to it. You might need to counsel the supervisor. He or she mightn't be alive to it. It might be a tone or style issue, and you can move reasonably quickly on that. And so that's my view. David, have you got the same?
Yeah, I think the prevailing school of thought in the work health and safety context is that there's no really such a thing as an off-the-record complaint.
Yeah.
Once the complaint is made, you're aware of it, you've got to deal with it, you've got to acknowledge it. It may be that for whatever reason it does fizzle out if a person says, look, I don't want to engage in any investigation, and I'm just saying this, that if you do take steps to look at it, practically it can't go anywhere because the person doesn't want to engage in the process. But you can't, I think, deal with the complaint as if it's not been made and sit on your hands and hope it'll all go away. There's the duty to be proactive because you're on notice of a complaint, even if some of the particulars of how it was made or why it was made might be require further scrutiny.
Thank you. Question 2 of the 3 additional ones, and this is about prosecution, but you might also want to speak to, I suppose, common law liability. Have there been cases where individuals have been prosecuted if they were aware of company bullying policy? So I suppose the company's got good policies in place and makes people aware of it, but then their behaviour is contrary to the existing policies.
We're not safety lawyers. We have a safety team at DWF. They do a lot of this work, but I know a bit about it. It's about it's about reasonable practicality, which kind of mirrors some of the common law tests, but it's a different arena. You're talking about a quasi-criminal offence of beyond a reasonable doubt. And there is capacity to prosecute individuals. There's none that I'm aware of in this space in Queensland, I might add. In Queensland, I don't profess national expertise on safety, but you need to be alive to your director's duties and duties of due diligence under the safety legislation. But generally, you'll find that workplace health and safety, because they have an onerous criminal standard to discharge, not always, but they often take on cases where they're really reasonably confident they can meet, they have a prima facie case and they can discharge their onus of proof. So it's not impossible, but not as we speak in Queensland.
Thank you. And the final one here is, if an employer becomes aware of bullying and harassment and they approach the person who's been bullied, but that person doesn't want to take it any further, what are the obligations on the employer to investigate?
Yeah, it's probably very similar to a response for the first question. It can be difficult. As I said, I'm no health and safety lawyer. It's probably question for getting some advice on the matter in that respect. But as I said, it's from a statutory and a common law perspective in terms of giving rise to an injury. I think the foreseeability and the reasonableness arises in great part on context and being put on notice. So if you are on notice that something's occurred, you've got to take steps. Now, it may be an employment law question whether you can compel someone to engage in an investigation. I don't know the answer to that. It may be no. But as I said, proactively, once you're on notice, you have to do something. And as I said earlier, practically it may not amount to much if the person doesn't want to participate in an investigation or withdraws the accusation. There's not, I would think, a great deal you can do from that perspective, because you wouldn't have the evidence base from which to make any findings and probably take any action.
I agree with that, David. I mean, you're still on notice, but of that person's potential, and you're still on notice of maybe a dynamic that is less than helpful that you might want to consider and counsel and review. But yeah, it is a bit dependent, because you have an obligation to investigate it. It's dependent upon, to some extent, the findings you make are dependent upon how people want to engage. And people are entitled to withdraw concerns, but you've really got to be satisfied that there's no coercion or pressure involved in that, and that otherwise you're otherwise satisfied that you don't need to look at it further. So there is a little bit of nuance factually in some of those questions, but I think David's hit the point well, that if someone withdraws, if you like, it can be at a practical level difficult to know what to do with that.
It'll be tough.
Thank you. Now, I jotted down a point for myself, and it's more a point than a question, but feel free to weigh in if you'd like to. And I think we mentioned earlier on something about employers potentially challenging the acceptance of statutory claims, and that's fine. It's important for employers to communicate with WorkCover and give their side of whether they think it was management action and whether it was reasonable and undertaken in a reasonable way. I suppose the point I wanted to make was always try to make sure it doesn't become adversarial at that point. I suppose it's your worker that's lodged a claim, whether they're suffering an injury as defined under the Act is in question, but they're still going through something, and they will always see the response as part of procedural fairness. The worker will see the response. So keep it factual would be my tip there, and give us as much information as you can, and obviously make your case. But just remember that the worker's going to see it as well.
Yeah, I think that's a really good point, Tim. And I think that the breakdown in the employment relationship is an issue that really surfaces in psychological injury claims. Because, if you like, there is this false element about reasonable management action that can be imported. So what Tim says is absolutely right. And when we help employers in this space, we really look at the application of reasonable management action factually. And we're alive to the fact that, you don't want to exacerbate anything because the worker, as Tim says, will see it. And so that's really good advice.
That's all we have time for. Thank you so much, the three of you, for preparing and presenting today. We really appreciate it, and I'm sure everyone listening appreciates it as well. If we haven't gotten to a question, I'm very sorry. We've just run out of time. As I mentioned earlier, this is recorded. It'll go up on YouTube. We'll send out the link. We'll send out the survey. Damien mentioned the Shockman case. I'll just put in a little plug. All of our previous webinars are up on our YouTube channel, and there's you'll see on there's a 10-minute one in which we talk exclusively about the Shockman decision. So feel free to check that out if you'd like to know more about that. You can submit feedback. Also, please feel free to submit suggestions for future topics. We do these common law ones every other month. And in between, I think WorkCover just does general topics unrelated to common law. So if there's ever anything you think that should be covered in detail in an hour-long session, please feel free to let us know. If you're interested in attending any more of these, please keep an eye on your email, LinkedIn, the events page on the WorkSafe Queensland website. And that's all from us. Thank you again, DWF and our Toms.
Thank you. Thanks, guys.